Good afternoon, folks. This is the latest in our series of Wednesday webinars in the family group at One Pump Court. It's with me, Jamie Presland, and Imogen Mellor today, looking at a practical guide to supporting parents in care proceedings. Parents end up in care proceedings often after a long period of professional concerns. You will probably have solicitors have supported parents through the PLO process. It might have involved detailed assessments. There'll be a perceived failure of the PLO process or a sudden crisis, and all of a sudden you're in care proceedings. And the parents are faced with a time-limited process expected to be 26 weeks, where they have no option but to jump through every hoop they're given by professionals if they hope to care for their children. And time really is of the essence. This talk looks at what resources can be available to help support a parent's case when the long-term welfare of the children will soon fall to be determined by the court. Topics for today. The webinar will last about 40 minutes. We'll look at assessments in care proceedings, we'll look at outside support, we'll look at sources of information, and we'll have a 10-minute session of questions and answers at the end. There should be a link at the foot of the screen. We hope that you can all see the PowerPoint presentation. If there are any technical difficulties, you could try putting a question in the box, but we aim to take them at the end if it's not anything technical which is an issue. The slides will be sent out to participants after the webinar. There'll be a recording available soon at onepumpcourt.co.uk. Now over to Imogen for assessments in pending proceedings.
Thank you very much, Jamie. And of course, thank you all very much for attending on this afternoon. I'm going to be taking you through assessments under Section 38(6) of the Children Act. So what is these assessments? Well, they are medical or psychiatric examination or other assessments of the child where the court makes an interim care order or interim supervision order. So in essence, during care proceedings. And Section 38(6) is supplemented by subsections 7A and 7B, which essentially provides you with a checklist of things that the court needs to consider when deciding whether to order such an examination or assessment. And this includes whether the examination or assessment is necessary to resolve the proceedings justly, and also other factors, for example, the impact of any examination on the child. So if, for example, you have a case where a child has been involved with a number of different professionals, it might be that the court feels that a psychiatric assessment, for example, might be particularly burdensome and difficult for that child, and they might deem it to be a negative impact for that assessment to be ordered. The leading case on Section 38(6) assessments, particularly in the residential unit sphere, is the case of Rewhy a Child. And the summary of the facts are set out in the PowerPoint. In essence, the local authority successfully appealed the first instance decision whereby the mother's application for a detox residential placement had been allowed. And that was following the reports from a psychiatrist who said that the mother required intensive drug treatment and preferably at a residential unit. And the court, when looking at this case, provided guidance on the court's statutory powers under sections 38(6) and 7. And first of all, the court said that there are two questions which needed to be answered in the affirmative in order for the court to allow an application under section 38(6). The first question is whether the proposed placement or assessment falls within section 38(6). And the second is the question of whether it is necessary to resolve the proceedings justly, and having regard to those subsections that I've taken you to already. So what falls within an assessment under section 38(6)? So really targeting that first question. Well, it goes without saying that the statute makes it clear that it can be a psychiatric assessment or a medical assessment of a child, but also other assessments. But the courts have made it clear that of primary importance has to be the child. So it is a child-focused assessment or examination. That could be an assessment of the child with their parent. But where it is an assessment, for example, as to whether a parent can abstain from substances, that does not fall within section 38(6). And the court also referred to other cases, including Re G, where Baroness Hale, as she then was, provided further guidance, stating that such an assessment or examination needs to be for the purpose of obtaining information that the court needs to resolve the matter. And she highlights that often there can be a difficult line to be drawn between gathering information and providing a service, providing treatment, for example. But what she highlighted is that the provision of services and treatment ultimately falls into the purview of the local authority. The key issue for an assessment ordered by the court under section 38(6) needs to be obtaining information. It can also be that these assessments can look at the attachment between the parent and child, and the ability of the parent to manage risks and attachment styles, and so on. But ultimately, as I've said, the focus needs to be a child-focused one. And these assessments or examinations should only be commissioned where there is no other way of obtaining this information. So in the case of Re Y, the court noted that there were other sources of information that would have obtained the relevant information. So that being evidence from the social workers, the drugs programs that the mother was involved in, hair strand tests, and so on. So if you are considering an assessment under section 38(6), you need to think very carefully and be able to persuade the court that this is the means of obtaining the information that is required to meet the statutory test and to meet the test set out in that case law. Other key points regarding residential units. The local authority cannot be required to fund treatment of a parent. And I'm going to come on to matters regarding funding in due course, but it's important to really highlight that particular point at the outset. If you can, it's best to engage local services as soon as possible. Time really can make a huge difference in these sorts of cases, and particularly as placement at residential units can take a number of weeks, sometimes 12 weeks, sometimes it will of course depend on the particular case, but you want to have the opportunity for your client to fully engage as soon as possible, and also considering the timescales for the child in the case. A top tip: if you have identified a placement that you think would be helpful for the particular parent, you can approach that placement and seek a preliminary view as to whether they can offer that parent a place, and indeed whether that placement would be suitable. And once proceedings begin, I'd advise, if you can, seeking leave to disclose papers that might be helpful for that unit to provide a view as to whether they are able to assist. Costs, as I've said, an important consideration. When it comes to drug treatment, the cost of a residential assessment will be shared between the children's services in terms of the assessment aspect concerning the child, and the treatment of the parent will be shared between the local authority, the adult services, I should emphasise, and the NHS. Specialist units will often require the health service to fund the treatment element, before placement is necessarily agreed by the local authority or ordered by the court. And these questions about funding vary between locality as well, and it can involve a number of meetings and reviews by the relevant professionals. So it is important to try and keep on top of the different multidisciplinary agencies involved and ensure that these discussions are happening so that your referral can take place as quickly as possible and it isn't delayed by questions about who is funding. Therapy, if there is a residential unit where therapy is being provided as an extra, it probably needs to be adult social services providing the costs and NHS funding. And again, I emphasize the importance of trying to find out who is going to be funding as soon as possible. We've included in the slides 2 examples of some specialist residential units, the Trevi and Symbol. It's useful to consider when thinking about residential units, looking outside the locality if you don't think that there is a residential unit that necessarily meets your client's needs. It is possible to have referrals elsewhere. Courses. In terms of courses, I'm sure many of us will have had cases where parents are referred onto different courses, for example, parenting courses. And it's really important, like with residential units, to think specifically about what your client needs and what is going to help their case. It sounds obvious, but it can make all the difference. And for example, you might have a case where your client or the relevant party isn't in the local authority's threshold document. There are no allegations against them, but it might be that a particular course would assist them in forwarding their case. So, for example, if a parent seeks to be the primary caregiver of the child, but they haven't done so before, it might be helpful for inquiries to be made of the local authority for that parent to be referred onto a parenting course to provide them with the requisite skills. And again, timing is of the essence. Referrals can take a number of weeks and courses themselves can take a number of weeks. And you want to be able to show that your client has been engaging as soon as possible. Also, think about what the child needs. You might have, for example, a child who is neurodivergent. You might have a child who has particular needs. And there are courses out there which can tailor to those particular needs. And just as an example, the final point on this particular slide refers to the non-violent resistant parenting approach training course, which I had in a case recently where that particular child had exhibited violent behavioural traits at times. And this particular course was very helpful for the parents to understand how to navigate parenting and how to tailor their approach to their child's particular needs. Also think about charities and organisations outside your locality. Just as an example, Solihull Children's Services have a parenting course, which I have seen being used by other local authorities, particularly where parents might have difficulty attending in person and the local authority doesn't have an online option themselves. So that concludes my slides on this part of the presentation. I'm now going to hand over to Jamie, who will start off by talking about addictions.
We were looking in the last slide at community drug and alcohol services, which are absolutely key. If your client has got a drug or alcohol problem, it will have been one that's ingrained for months, for years. It needs to be dealt with, bearing in mind that the court is looking at the children's timescales and won't let the children hang about. Um, Making the most of the time, often for parents, if they're separated from their children in care proceedings, it's devastating. But you want to make the most of the time that they have to be without the children. Um, if they are committed to dealing with a long-standing problem, drugs, alcohol, gambling, there are community resources out there on top of the uh, health and social services provision of the drug and alcohol services. Alcoholics Anonymous, Cocaine Anonymous, Narcotics Anonymous, Marijuana Anonymous, Gamblers Anonymous, all offer variations in different meetings of a 12-step program. That there can be a spiritual element to that, which many clients of my experience find quite reassuring. It's very rarely a directly religious element, but that can vary from meeting to meeting. Each of these links on the slide when you get it um, has got find a meeting links. Step Change, really helpful organisation for debts and for gambling. Support for people affected. The AdFam link is a link to lots of support services. So, for example, you might have one parent has got the problem, the other parent hasn't got the problem, but has to live with them. Support for people affected is set out in quite a lot of detail on the AdFam website. Next slide, we're looking at detox, drugs and alcohol. The community drug and alcohol support is the access point for a residential detox. It's expensive. Social services and NHS funding arrangements will only back adults who have shown a real commitment. So it's really important that the clients understand they've got to show the commitment. They'll need to be encouraged to engage openly and without delay. If a parent can't join a residential assessment, and that sometimes happens. The court isn't satisfied that the child is safe or that the particular assessment is necessary with young children, and the children are being looked after. A residential rehab or detox is something which might be the best way forward to deal with an established problem. After a referral, a place is likely to be available within about 3 weeks. So lots of different providers across the country. Most of them are engaged by the NHS. There's useful information in the links below. The NHS one, a general one about services that can be available, but Rehab Online and UCAT are both resources which can help identify a rehab unit in your client's area. The PLO and planning ahead. You'll probably often find that the PLO seems weighted against parents, unless the parents appreciate how serious the situation has become entering the PLO process. It can simply be an evidence gathering exercise for later care proceedings. In terms of helping the clients through the PLO process, trying to avoid it becoming care proceedings, accessing information yourselves about the social factors which have led to children's services involvement can help achieve more professional understanding through the process. Engaging with community services to address the perceived weaknesses can ease the problems and also help get the social workers on board. Generally, in my experience, social workers like to identify a problem. What they want the parents to do is to accept that there is a problem and to take the social worker's help in dealing with it. Those are the rules of the game, and the clients have only got a few months to realize that that is the situation. So the sooner they're on board, the better. It's important to lay the foundations for care proceedings if the PLO goes wrong, and we know from experience it often does. Two different takes on the PLO. There's what the judiciary say it is meant to be, and there's what the family rights group says it is. Both useful sources of information. Housing is often a key factor. It is the responsibility of the local housing authority. In a unitary authority, that may be the same as children's services. The way local government is broken up in different places, it often isn't. There is a duty of cooperation under Section 27 of the Children Act. There was quite an unhelpful judgment early on in the Children Act in the early 90s, saying that in a unitary authority, The housing department couldn't be asked for help by children's services. Most people seem to have forgotten that that exists, but the local authority can ask help from different public bodies, in particular from housing as to support for children and families. The main housing duty you will hear talked about is Section 193 of the Housing Act. It's got different elements. The first is that the applicant must be eligible. Secondly, they must be unintentionally homeless or threatened with homelessness. So, for example, is it unreasonable to continue to occupy the home where they are? If you have a family of 8 in a 2-bedroom flat, then they are homeless at home. If you have a family whose flat or house is just dripping with water and damp and is not safe, they're homeless at home. So they can apply as homeless to the local authority. They need to be in priority need, and we'll come to that in a moment. But it's really helpful to build up a relationship with a reliable housing solicitor. If you're in a big firm, there's likely somebody in the firm. But if not, there'll be somebody local or somebody by reputation. You can probably help get them to help your clients, and you can help them because they're not going to know about children's and social services law. And when their clients are involved in care proceedings, you can help each other. Key documents in relation to housing, the Homelessness Code of Guidance is constantly being updated. It is online. There's a link to chapter 1. It is a very technical area of law, but it is put into terms that even I can understand by Shelter. I recommend very much looking at the Shelter website. There's a link to their main part about housing there. Next slide, priority need. So priority need, the applicant or somebody that they live with is at risk of abuse from a partner, an ex-partner or a family member, is pregnant, lives with their dependent children, is a care leaver aged 18 to 20, or is homeless because of a crisis, fire, flood, or other disaster. In other situations, the applicant has to show that they are vulnerable and has a priority need, and vulnerable means at much greater risk of harm than most people if they become homeless. So, for example, if there's disability or serious illness. Eligibility is an enormous technical matter. It depends very much on immigration status. Are the family eligible? Best way to find out is click on the Shelter eligibility checker. Support for families who've got no recourse to public funds can include support under Section 17(6) of the Children Act. So support for children in need can include accommodation, it can include essential living needs for their children, as established in the Appeal of Birmingham and Clue, which remains good law. Might the family be eligible for asylum support? Children's Services can bridge the gap in the meantime. Is judicial review potentially available? Again, having a friendly housing or community care lawyer on hand is something to add to the armoury. Next slide. Fulfilling housing duties. First of all, the local authority or the housing authority provides temporary accommodation pending a homelessness assessment. That's Section 188. It is an area of law where if accommodation isn't provided, that there's still a possibility of applying for judicial review, but it's quite technical. Bed and breakfast accommodation is not suitable for children. That means accommodation which isn't independent, doesn't have its own bathroom, doesn't have its own kitchen. So there are lots of places identified as hotels, which aren't really a hotel like the Hilton, but have got a shared kitchen. They've got shared bathrooms down the corridor. People whose household includes children or a pregnant woman must not be housed in bed and breakfast accommodation, according to the regulations and the guidance, unless there is no other suitable accommodation available, and then only for a maximum of 6 weeks. That is the law. It's often honoured in the breach. Suitability depends on the duration of the accommodation and local housing conditions. A place may be suitable for a few weeks, which would not be suitable for a few years. It might be far away. It might involve a change of schools and GPs. And if you've got a family who are in the middle of care proceedings, you don't want them being scattered to the four winds. So it's helpful to have strong housing advice to challenge any suggestion that they ought to be accommodated away from where the children are. The local authority's duty to secure accommodation ends when the application accepts an offer of suitable accommodation or refuses an offer of suitable accommodation. If your client has got a pending homelessness application, the advice that any housing solicitor would give them, I have done housing law, is it's better to accept the accommodation that's offered and apply for a review of it, because it's quite easy for the housing authority to demonstrate that accommodation was suitable. So accept the accommodation, apply for a review. The review might be subject to an appeal to the county court. The duty to secure accommodation ends if the applicant becomes intentionally homeless or ceases to be eligible for assistance, a change in immigration status, for example. Community care. Consider, do your parents have unmet support needs themselves? There is a link there. It's a technical complex area. That there are deserts of community care legal aid, but whether or not your client's entitled to apply for legal aid, not legal aid, sorry, is entitled to apply for community care support, a Care Act assessment under the 2014 Act. There is a link on the Gov website which will take you to the local authority where they live. Services that can be provided include home care help with things like cleaning and shopping, disability equipment and adaptations to the home. There can be major adaptations, putting in a ground floor bathroom, putting in a ground floor extension with wheelchair access. Even in rented accommodation. Day centres to give a parent or the person who cares for them a break. Daycare for the children. Help with parenting, such as parenting classes, can fall under a Care Act assessment. Do bear it in mind. And it takes a while, but once the assessment is underway, that's likely to be completed, resources in place by the time you get to the end of care proceedings. Next slide, please. Special educational needs. Good news in the budget today that the money being put into special educational needs is going up, and high time. But does any child or young person in the family have unmet special educational needs? Young person for these purposes, bear in mind, goes up to the age of 24. So a child of compulsory school age, so from when they reach their 5th birthday until they reach 16, special educational needs are also to be put in place for children who are preschool. So there is clear guidance, which we'll come to in a moment, about identifying special educational needs in the under twos, so that proper resources can be put in place. The EHC plan, the Education, Health and Care Plan, technically is what used to be the Statement of Special Educational Needs since the 2014 Act. That sets out education, health and care resources which should be put in place. The next slide. So section 37.1, where in the light of education, health and care needs assessment, it's necessary for special educational provision to be made in accordance with an education, health and care plan. The local authority must secure that the plan is prepared and it must maintain the plan. By section 46.1, that continues until the end of the academic year during which the young person attains the age of 25. So there may be a young person who's part of the household, who's on the threshold of adulthood, but nonetheless is eligible for special educational needs support. Timescales, it's all quite technical, but the guidance, you've got a link there. Page 154, there's a really helpful flow chart if you want to try and work out what's going on with your clients' children at different ages. Children with a disability, again, this is in section 17 of the Children Act. For the purposes of this part, so part 3, support for families and children, a child is disabled if he's blind, deaf or dumb, or suffers from mental disorder of any kind, or is substantially and permanently handicapped by illness, injury or congenital deformity, or such other disability as may be prescribed. And in this part, development means physical, intellectual, emotional, social or behavioural development. Health means physical or mental health. Are the children getting entitlements they should have to meet with disabilities under any of those headings? Again, there's a link there to start off with help for a disabled child. Parent carers dealing with a child who has a particular disability are going to be entitled to a parent carers needs assessment. Section 17 ZD, ZE and ZF of the 89 Act set out the scheme for that. Children with continuing healthcare needs, children can have a continuing care package if they have needs arising from disability, accident or illness, where that can't be met by existing universal or specialist services alone. So they would have an individual care package. This is what might have nurses coming in at night to change suction tubes and so on. National Framework for Children and Young People's Care, what was meant to be updated a couple of years ago, fell by the wayside under the last government. Hopefully it'll be updated again quite soon. Checklist lets you know the questions which are going to be asked, and there is a guide putting this complex area of law into simple terms for young people and parents. There's a link there which you'll be able to access. And the next slide. Records. So children's services may not always be really helpful and they may not seem well motivated to your client, but what they will do is write down what they have done. And records are kept on computer systems. They're generally accessible at the touch of a button. The subject access requests under the General Data Protection Regulations, which is a bit of EU legislation which remains in force in the UK, and indeed the EU legislation was based on our Data Protection Act and Britain's experience and sort of groundbreaking legislation in this area. The position now, the data holder might require proof of consent and identification. A parent can apply on behalf of a child. The response should be provided within a month. The organisation cannot charge. There are links there for the ICO, the Information Commissioner's Office, links typical from a local authority for children's services, housing and community care, how to get information from schools, from health and GPs, and the ICB, which commissions health resources, and private housing or the Peabody Trust. Final topic I want to raise is complaints. You can make a complaint, a client can make a complaint about children's services while care proceedings are underway. You need to make a judgment call. If it's not justified, it may just antagonize a social worker. But if the social worker is just in the wrong, then it can be quick and it can make a difference in the timescale that the proceedings are running on. The first stage is a team manager resolution that rarely achieves anything. The second stage, an independent person is appointed. The third stage, there's a panel hearing. The panel can award compensation. As a helpful summary from the House of Commons Library, the statutory guidance from 2006, but it still remains a law. Bear that in mind. You can make complaints and they can make a difference. Now, any questions? We've got short questions. You can use the link at the bottom of the screen. If we can't deal with a question today, you can email us directly and we'll get back to you. And please remember that our answers and this talk are meant as a guide. It's not a substitute for advice in a particular case. Do we have any questions, Imogen?
Currently, I can't see any in the chat. I'm just having a look at the moment.
So at the foot of the page, you should have a little question mark in a box that says Q&A. And if you want to add any questions, you're very welcome to. If not, you can drop us a line. You know where to find us.
I can see that one participant has raised their hand. Yes, they've put a question. So someone has asked, complaints during care proceedings or only before?
Both.
Both.
You can complain before. It came up quite recently in a case that's still ongoing, and the local authority has said, we think we won't be able to continue with the complaint because we've issued proceedings now. Local authority lawyer agreed with me that that was completely wrong. There is nothing to restrict making a complaint as long as it falls within the very broad terms of Section 26.
Yes, and as Jamie said before, any complaint, make sure that it is a reasonable complaint. If you do see that there's a reason to make a complaint in the PLO process, by all means, it's good to raise it sooner.
And a helpful update.
Yes,
Not a question. Standard directions now provide permission for solicitors to send papers to residential units, so no need to wait to seek permission at the first hearing. We've put that right in our notes.
thank you very much for that comment. Um, any other questions that we have coming in? Well, if anyone does have any further questions, you can, of course, email Jamie and I. We have provided our email address in these slides, and of course, a recording of this webinar will be uploaded to the One Pump Court website. So you can, of course, access the recording and the slides and review at your leisure. And of course, email us if you have any further comments or questions. And thank you very much for
And the
attending.
last few weeks, we've had three seminars sessions which have all gone well attended. Thank you for attending. Further seminars in a couple of months. If there are topics you'd like us to cover, please let Scott or Chloe, our clerks, or Cecily know. We're happy to try and cover areas which would be helpful for you. I think we have got a slide that says thank you for joining us today. But it'll probably all go horribly wrong if we go back to that.
Let's leave it there then, Jamie.
Well, thank you very much, everybody, and good evening. Hope your day goes well tomorrow.
Thank you.